In my think tank tonight. Joining us in Orlando, criminal defense attorney Mark O'Mara, represented George Zimmerman years ago. Also with me, criminal defense attorney David Schnipper, former commander of major crimes, Lieutenant Colonel Adam Lee, and criminal defense attorney Ashley McMahan. Welcome to you all. Mark O'Mara, down in Florida, I want to begin with you and your reaction and what you believe the reaction to this audio recording will be for that jury down in Orlando.
Well, first of all, a technically about perfect presentation by the state. They did it very well. They put on the case in a very methodical way, did exactly what they had to do. The build-up, it wasn't dramatic and obvious, but the build-up was to what they knew they had, the crushing blow, which was going to be his own confession, his own words, his own video. And you cannot look at that video, you can't listen to his words without, like you say, that anger welling up. Anyone who looks at it has to say, that person is disgusting. That person is worthless to do something like that. And it was his own words. It wasn't even prosecution arguing that yet. They'll argue it in closing. But yes, it was a devastating video. And what I couldn't get away, because I've watched the whole trial, what I could not get away from when I started to hear his own words was that this is what he wanted to do. I don't mean just the murder. He is presenting as almost an act, almost a presentation, like this is who I am, I'm going to show everything that I can do to make myself as bad as possible. And I say that again, not to offer him an excuse, but even the words that he used, I knew she was going to die. That's when I knew it was over. That's when I plunged the knife in. It is as though he's almost reveling in his own presentation of how he is the master killer. And I don't know how that's going to play inside his head, but that is not going to play well with the jury deciding his fate.
All right, coming back here in studio, and Ashley, you know, the backstory for this recording is he calls and he writes to investigators, sends them a letter to have them come down here. He orchestrated this whole thing.
Right. Vinnie, I think you really hit the nail on the head when you said, you know, sometimes when we're watching these trials on Court TV and we're sitting in the comfort of our own living room or our own bedroom, and it looks like these people are so distant from us, but you don't realize how small this courtroom is and the casualness with which he gave this confession and how he casually just talks about killing this woman in front of her loved ones that are sitting in the courtroom very close to him. I mean, the jurors are going to see the impact of that, and we're going to get to see their reactions and things like that, that they're going to have to make an opinion. Is this person's life worth saving? I don't know that when you're sitting that close to him and hearing those words.
Because the jury in this courtroom, David, is right next to him. I mean, most courtrooms, the jury is on the prosecution side. No, here, they're right next to him as they're hearing these words. I don't know if he can overcome this.
Absolutely not. I mean, they have a front row seat, but you know, in Florida, the only thing that the defense in Scott Nelson has going on their side is the laws changed in 2017, where it's actually a lot more difficult to get the death penalty. If, let's say, he is convicted guilty, what it looks like he's going to be, there's going to be a subsequent death penalty hearing where there's going to have to be aggravating factors which will be brought up, where the jury will then decide, again, beyond a reasonable doubt. We assume that that's going to probably happen, but here's the caveat with that is, will there be a unanimous 12-0 vote for the jury to forward their death penalty?
Defense can play to just one juror down in Florida.
Exactly.
Just need one.
And that changed in 2017, where it went all the way to the Supreme Court. It was Hearst versus the state of Florida. Went all the way to the Supreme Court that said that it was a violation of the Sixth Amendment and their right to a jury trial, to where now you have to have a unanimous 12-0 vote. So even if he does get convicted, it's still, there's more hoops that have to be jumped through. Again, you find that one juror. I want
to know who that one juror is going to be after hearing this. Now, Lieutenant Colonel, the way he said what he said, that tone, have you ever in your career heard a confession to murder done in such a matter-of-fact way?
Actually, I have, Vinnie. Unfortunately, I have. But it never amazes me, never ceases to amaze me when I hear something like this. Just watching that, I can't imagine how difficult it was for her husband to sit through that without wanting to jump out of his chair at the defendant. That is something that no one should have to really to listen to or go through, no family member. And I can't imagine being in his position today.
But an amazing job by the investigator, because you have to play along with this casual tone while you're listening. How do you do that as an investigator? I mean, I know, I understand you have a job to do, but I don't think I could do that, listening to these words and still be able to retain your composure and that rapport to get more information from him.
Most investigators have to be highly trained in that situation, because you can't imagine sitting there having somebody describing such a heinous act and basically you wanting to put your hands around their throat, because you put yourself in the position of a family member. If they're talking about a person, you're thinking of, what if that was one of your family members? Would you be able to sit there and listen to someone describe that murder in such a nonchalant manner?
And if I could just back up what the lieutenant said, I used to live in Orlando. I know the Winter Park, Florida area well. It's a very nice upper middle class area. The most unforeseen, unbeknownst thing would be that something egregious and vile and heinous would happen there. So and they called her Jenny Poppins after Mary Poppins.
I know.
And so the fact that, you know, her husband wakes up and all of a sudden this happens to his wife, in the percentage that this would happen there is basically less than zero almost. So I mean, it's just a horrible, horrible thing that happened, and it kind of took me back to where the Ted Bundy movie came out, and the title was Extremely Wicked, Shockingly Evil, and Vile, and that's exactly that's what made me think of that.
One of Ted Bundy's trials, also in Orlando, folks. Our 13th juror question for you tonight. Can Scott Nelson help his case by testifying? The jury heard his words today, but tonight he has to decide and let the judge know in the morning whether or not he's going to take the stand. And don't forget, he already sent a letter to the judge saying that he was going to testify. Let me know. Go to our Facebook page, vote yes or no. We'll reveal those results at the end of the program.
Ms. Burdick.
Your Honor, at this time, the state of Florida rests.
Members of the jury, in just a moment, we're going to take a brief recess. During the recess, although the state has rested, you are still under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. You're going to continue to leave your notepads and your pens on your seat. Please follow the deputy in the jury room. We'll bring you back as quickly as we can. Thank you.
So the prosecution has put in all the evidence they believe they need to prove that Scott Nelson is guilty beyond any and all reasonable doubt. And again, the big piece of evidence at the end of the case, the confession of Scott Nelson. It was an audio confession. He's the one that wrote a letter to investigators to bring him down to the Federal Department of Corrections down in Miami so he could talk to them and give them all this information. Now, it was difficult to listen to at times, but it's important. This is a death penalty case. Prosecutors want to get in all the evidence they can. This next piece of that confession I want to play for you, I think could be crucial in this jury understanding who this guy really is. In this part, he describes the murder and how after the murder, he drove back into town and, you know, he was a little bit hungry. So he went to the local 7-Eleven to get some pizza. Take a listen.
Let me think, that was it. That was the night I sat there and I thought about what I've done, everything, and I was hungry. Yeah. And, you know, this is the evil part of it all. With concern to the, after everything that's been gone on, here I am, I'm back in Winter Park, and nothing's changed. No. Okay, I may have a couple $100 in my pocket. A girl is dead. And I still have complete contempt for Winter Park.
Did it make you feel any better?
No, it didn't make me feel any better, but I just don't understand how, you know, things are the way they are. So I went into 7-Eleven down on the end of New York or whatever street it is there. Mm-hmm. And right around the corner there at the 7-Eleven, I went and I ordered a pizza.
I was hungry This is how he describes his feelings after taking the life of Jennifer Fulford, a woman who on that day, her son had just had a child with his wife. She became a grandmother for the second time. A woman who dedicated her life to taking care of other people's children as a nanny. A woman who if he asked her for help, would have given it to him. That's the type of person she was. That's the life that was taken. That's what he's confessing to. It's not the biggest piece of evidence, Ashley, but I don't know how any juror can forget this piece of evidence as really understanding the character of this defendant.
Well, I mean, obviously, you know, he's the type of person, and you can tell this throughout his testimony. Every time he said anything, and we'll find out if he's going to testify tomorrow in his defense, but every time he said anything in his interviews with the police, in his confession, everything, he's just got this way of speaking that is not how any normal human being would describe the events that led up to this. And he's saying, you know, basically, I just committed murder, and then I walked down the street and I was hungry and went and got a pizza. I mean, the jurors are not going to forget this piece of information. They're going to say, okay, he felt so little about taking someone's life, this wonderful woman's life, which this day should have been one of the best days of her life. You know, she just became a grandmother for the second time. And instead, you know, he took her life, and now he's just going to walk down the street and do something that we all do, which is, you know, I'm hungry, I'm going to grab a bite to eat. That just speaks to an unwell mind.
And he describes these two things in the same exact manner. The same way he describes the murder is the way he describes getting a piece of pizza.
Well, I mean, I think it's the definition as a sociopath. He has no empathy. He has no conscience. He doesn't care. He's a narcissist. He's a psychopath. And look, this is somebody that spent the majority of his life incarcerated, especially the most of his adult life. So it's a game to him. You know, in my subjective opinion, I think that he has structure and he has more of a life. He knows the inside of a prison more than he can cope. He has no coping mechanism outside, so he doesn't care about consequences. And we know that his motive, based on his interviews with the detective, was that he didn't like wealthy people per se, or people who lived in the Winter Park area that had the nice cars or lived on the golf courses. And hey, there's a reason why the word misery loves company is there. He wanted to, again, what is it, 11 days earlier, he went and bought a knife, he bought the zip ties.
It's absolutely planned and plotted.
Planned.
I want to go back down to Orlando, Mark O'Mara. Mark, the fact here that he describes both things the same way, to me, tells us a lot about his character. But the other part of this story is that prosecutors were going to approach him about some plea negotiations, which the obvious result would be maybe you don't get the death penalty, yet he didn't want anything to do with it. I think he wanted the world to hear this audio recording and may want the world to hear him testify tomorrow.
And that's what we talked about a moment ago. It really seems as though he knows he's on stage, even during that interview. He's having the greatest time, it seems, almost, being the center of attention in this courtroom. And I will tell you, though he would do it over my gripping his arm not to, he may well decide he's going to talk to this jury tomorrow for the defense case. A huge mistake, but if his focus is on this sort of, like was mentioned, this sociopathic view, narcissistic view of his control over the world, he may just surprise us and get up there and start pontificating from the stand. Now remember, you know, the defense has told us it's going to be 4, maybe 5 days of mitigation. We know it's going to include some psychological testimony, so whatever happens tomorrow in the defense case, if they put one on, is going to be laying the foundation for whatever that psychologist or psychiatrist is going to come in and tell us what is wrong with this guy, why he did this, and why we may not want to kill him because of it.
Lieutenant Colonel, I want to ask you about his life behind bars. How does a guy like this get treated by other inmates? How is that relationship?
His crimes prior to this crime, probably he would be treated well. He didn't do anything to any children, to elderly people. His victim was a bank, I think, before this. At this point now, that he committed a crime against a woman, he's going to have some issues with some of the inmates there. Death row would probably be a safer place for him as opposed to general population. So maybe that might be part of his motivation for being put in death row. He'd be safer. He wouldn't be in the general population. He would have more free time out. Generally, death row inmates are treated a little bit better, actually, than your general population inmates because there's not as many of them, and they don't have to be together in one place at one time as much as general population inmates.
They're treated better until the end.
Right. And which, I might add, takes a long time.
Long time.
Right now, I think we were discussing out in the hall, there's about 340 inmates on death row right now in Florida. Wow. How long is it going to take if he gets a death penalty for him to finally be
And he knows that. He's not stupid. Our 13th juror question tonight has to do with Scott Nelson. Tonight he has to decide whether or not he's going to testify tomorrow. Can Scott Nelson help his case by testifying? Go to CourtTV's Facebook page or my Facebook page, Vinnie Politan Court TV. Let us know, yes or no, and then don't forget to like and follow the pages while you're there.
I'm a Winter Park resident, and my nanny is missing.
A 911 call signals the first sign of trouble. Jennifer Fulford, a nanny who's been working at this upscale Winter Park, Florida home, failed to pick up one of the children she was caring for. Her employer, a single father who's relied on Jennifer for the past 6 years, is worried and reports her missing.
This is what's unusual, is her purse is here.
Okay.
Her car's gone, her purse is here, and nobody's heard anything from her since 11.
The call sets off a desperate search and a plea on Facebook for information from Jennifer's husband. Jennifer was excited for an upcoming trip to Dallas to meet her grandchild, who was born earlier that day. Surveillance video captured Jennifer leaving this dentist's office the morning she disappeared. It would be the last image of her alive. 3 days later, police recovered Jennifer's body from this wooded area. Investigators say she had been stabbed and suffocated, her wrists and ankles bound, her face covered with duct tape. Police quickly tracked down her alleged killer after he withdrew $300 from Jennifer's bank account using her ATM card.
So you have the right to be signed, you understand that?
Scott Edward Nelson was arrested and questioned by detectives.
And I did what I had to do to survive.
Nelson would make several incriminating statements and offered some insight into why he may have made Jennifer Fulford his target.
I wasn't particularly happy with this.
Sure.
See, these people in Winter Park, for instance, right? They have everything by the They have beautiful homes and beautiful cars and golf courses. I'm walking down the street while all these rich people are walking around buying jewelry and they're having their good life and all this stuff. I wouldn't give a rat's about me.
At the time of the murder, Nelson was homeless and an ex-convict. Among other crimes, he had served time in federal prison for bank robbery. Now, Scott Nelson faces kidnapping and first-degree murder, charges that could mean the death penalty if he's convicted.
It's a day I'm describing with just one word tonight: brutal, for just about everyone inside the courtroom today. I'm talking about what happened in the Scott Nelson case. He's facing the death penalty, and he had invited investigators down to the Federal Department of Corrections down in Miami. Remember, this whole case is from Central Florida in Orlando, Winter Park. So the investigators go down to Miami. They record their conversation, their interview, their interrogation of Scott Nelson, but it's really kind of friendly back and forth, and he gives a full confession to everything. And today, inside the courtroom, the jury got to hear it, and they not only heard the details of what he did, he explained why he did it, and he did it all in such a matter-of-fact way. All while this is going on, don't forget that Jennifer Fulford, the nanny who lost her life, her husband, Her loved ones are inside the courtroom just feet away from Scott Nelson.
We'll come back to that. Okay, we'll come around to that. So you go upstairs, you look around, and it's when you...
I can't find anything of value. I don't bother.
Did you find these watches that she talked about?
No.
No. Okay.
No, I never did.
Okay. What made you think to get the comforter off the bed?
Well, something has to cover her up in order to take her out the front door.
Okay.
I can't just like take a bound out the front door.
Was she walking or did you carry her?
I carried her.
Well, when did you, the ATM, or pin for the ATM, how did you get that from her?
She told me what it was.
Okay. She told you?
Yeah.
Okay. Did you have to, you said she wasn't being cooperative, so I'm just trying to understand, did you have to do anything to her?
No. She was forthcoming. She just gave me that information.
Okay.
But everything else was like, she wouldn't tell me anything or give me any details or, she was,
Sure.
She was scared. I mean, and I would be too. Anyone in their right mind would be.
Okay. And could you tell me, like, when you said you got the comforter, you were going to put her in the car, you carried her to the car. Can you tell me everywhere that you duct taped her? Like, what did you duct tape?
Just her face.
You did her face?
Yes.
Well, when did you do that? Because if she's talking to you, at what point did you do her face?
When we got to the final destination.
Okay. All right. That's when you duct taped her face?
Yes.
Was that, so she was still talking and stuff when you left her there and then you duct taped her, or tell me about that?
Well, I chosen to bring her down that particular road because it seemed a lot like a wooded area to bring her. So I got her out of the vehicle and she started getting louder and louder, so I put some duct tape. And then louder and louder, so then, she's pleading for her life.
Yeah.
And things of such nature, so I duct taped her more, and then I had no intentions of killing her.
Okay.
But one thing led to another, and so I killed her.
Exactly how?
I stabbed her 3 times that I remember.
Do you remember where?
Yeah, once in the back, another time in the back, and then the third time I was walking away, and I thought to myself, you know what? I'm not going to let this bitch testify against me because they're going to give me the same amount of time. So I killed her. I put one through her heart.
Okay.
And I put it into her heart, but close enough to her heart. And then the first time I stabbed her, I don't even know if she realized she was stabbed. So I started duct taping her face more, and I decided I'm going to kill her. So I just duct taped her whole head.
Yeah.
And then I stabbed her again in the back, but I know it must have went through her lung. And that's when she started crying, like, oh no. She knew at that point she was going to die.
How could you tell it went through her lung?
Because of the area where, I stabbed her.
Okay.
The knife went completely to the hilt, if you will.
Yeah.
So I turned her around and I put some more duct tape on her. Then I was going to leave, and I said, all she's going to do is testify against me anyway. She would put me away for the rest of my life anyway. So so I killed her. That's what I did. So I put the knife into her heart area.
Yeah.
And she was still alive. But because of, I know a little bit about anatomy.
Sure.
So I turned the knife and she was still alive. And even though it's sunk right in the middle of her chest, I knew that and I just moved it, and she let out a gasp, and that was it. And she died.
And from the beginning, we've been talking about this overwhelming evidence in this case. Well, you've got the confession, which is the last piece of evidence, but you've got surveillance video, you've got the DNA, you've recovered so many items. And how did you recover them? They recovered them because of the words of the defendant. He led investigators to all these different places, including leading them back to the scene where the car was found to get the keys to the car. So this is a guy with a full confession. So now the defense is left with trying to defend him, and as we've been seeing during this guilt phase, what can you do? There's been very little cross-examination. After this goes in and the lead investigator finishes testifying, no cross-examination by the defense. So Mark O'Mara, let me go down to you in Orlando and ask you the question, what does the defense do? Because they have to decide by tomorrow whether or not they have a case, what that case could be, and they really haven't cross-examined many witnesses here.
Well, I think their whole focus has been try and get to that one juror to avoid death. And if that is your focus, then cross-examination, unless you're going to make a couple of good points, and some of the points they made might help in penalty phase, cross-examination is not going to help. You don't really want to frustrate the jury. You don't want to have objections coming out. So going sort of this laissez-faire, a very calm attitude at defense, may work if they're getting ready for nothing other than a penalty phase. So do they put on a case at all? Again, I do not think Nelson should testify, but that might be his final decision. It will be. And if he tells that judge, I want to testify, then he will. Dangerous as it might be, I look at some of the things he said, everything that, even the nuances, I know a little bit about anatomy, as though that's some necessary item to throw in. I knew she was going to die. He said that 3 or 4 times. She knew she wasn't going to be able to breathe. You know, those type of things, that type of major controlling of the nuances of it, I think that he's got a belief that he can play this as a stage manager and get up in front of that jury tomorrow and testify. Worst thing he can do, he needs to wait and let his attorneys do the job in the penalty phase and bring on some experts.
Yeah. How difficult is it to defend a case like this, where you've got overwhelming evidence? I mean, what do you do?
I mean, it's extremely difficult in terms of this part of the case, but as Mark said, and I'll just jump on him, I don't think, and his attorneys are board certified, meaning they're very experienced, seasoned with death penalties. They've been through it's not their first rodeo. So they're looking one step ahead to the sentencing phase, the death penalty sentencing phase, after the fact that most likely he is convicted. And that's where, is he going to testify or is he not going to testify? And that's where the defendant must make the final decision. The attorneys, we can advise, but the defendant makes the final decision. Now, I don't think it would be a bad thing for him to testify just for the fact to maybe come out with some things early on, get a step ahead of the game to find that one juror that would be against the death penalty.
Here's the problem. I can't see any human being connecting with him based upon what we've seen, right? I mean, how difficult is it going to be for them to get up and try to make an argument as to why his life is worth saving?
Well, I mean, just like Mark was saying earlier, you know, it's up to the defendant. He's very controlling. He's come off as very controlling in everything that he said to the cops. You know, I would not be surprised. Now, I don't know this for sure, but I've had plenty of experience with difficult clients and difficult defendants that think they're a little smarter than everybody else that's involved in the case. I wouldn't be surprised at the lack of cross-examination in this case, and maybe him testifying is him dictating to his attorneys, because it is his decision and it's his life on the line at the end of the day, saying, look, I know what's best for me. I know what's going on here. I don't want you to cross-examine these people. I don't want you to say anything. I'm just going to get up and say my piece, because I think at the end of the day, this is a show for Scott Nelson. This is all about him, and if he's going to go out, I think he's going to go out with a bang, and he wants everybody to know his story.
All right, our 13th juror question. Can Scott Nelson help his own case by testifying? He has to make that decision tonight. Let me know. Go to my Facebook page, Vinnie Politan Court TV, or Court TV's page. We got the poll up for you every night.
The field where Miss Fulford was recovered is very high grass. At some point, some of this grass was over our heads.
All right, Mr. Nelson, have you had an opportunity to talk with Ms. Moore about this issue?
Yes, she brought it to my attention. You know, I just lost a couple seconds there. No, I agree with that. I agree.
You agreed to proceed?
Yes, Your Honor.
I will be stunned
and amazed if this guy doesn't try to get up on the stand and make a spectacle out of himself and of this case. I don't think he's taking it at all seriously. I don't think he's showing one bit of sorrow or remorse.
Did the Winter Park Police Department have success in locating any items of potential evidentiary value on that date?
We did.
Is that the position in which the knife was found, or did you put it in that position?
No, ma'am, that's exactly how we found it.
There were 4 stains that were matched Miss Fulford.
All right. And how many matched Mr. Nelson?
There was 3 stains that were single source that matched Mr. Nelson. There was 2 stains that was a mixture that had both Mr. Nelson and Miss Fulford as contributors to those mixtures. It was greater than 700 billion times more likely to occur if the source of the DNA on the evidence came from Mr. Nelson than from an unrelated individual.
I wanted to make an example of Winter Park.
Right.
Okay? Right, wrong, or indifferent, be it evil, be whatever, that's what I was going to do. And that's when I pushed the door and pushed it in, I went and shut the door, and she screamed.
Okay.
And she was, frightened.
Sure.
And I had a knife. I'm having a hard time having compassion because I've been brutalized for so many years that I don't even know what compassion is anymore. But one thing led to another, and so I killed her.
Exactly.
I stabbed her 3 times that I didn't remember. I know that you're going to find the body because I could have found other locations. See, do you understand that I left everything for the law enforcement to find?
Okay.
Because I didn't want this to be an anonymous thing. I wanted society to know.
This was a horrible day. Just imagine being that family, and Robert Fulford specifically. He, of course, was breaking down at times.
And the results are in from our 13th juror question. Can Scott Nelson help his case by testifying? And just 10% of you say yes, 90% of you say no, but I'll tell you why this still gives some credence to maybe him testifying, because remember, when it comes to the question of life or death, as our guests have been talking about tonight, you just need to reach one juror. That could be someone in that 10%. All right, so today is done, but here's the question I have from my think tank, and there may be an obvious answer, but I never know. I have to ask it. Who had a better day, the prosecution or defense? We'll begin tonight with criminal defense attorney Mark O'Mara, who is outside the courthouse in Orlando. Mark.
The defense is not going to have a good day in this trial. There's 2 potential good days for the defense. One, if they somehow avoid having their client testify in guilt phase tomorrow. And the other day is if they get a recommendation from at least one juror to avoid death. And that's only going to happen if they have some compelling evidence to convince the jury that this guy is so mentally ill in some form or fashion that he deserves just a modicum of sympathy. Those are the only good days that they can possibly have in this trial.
Ashley McMahan, criminal defense attorney, who had a better day, prosecution or defense?
Prosecution, hands down. I mean, ending with his confession, it was so callous in the way that he described it. Giving the jurors the transcript to read of everything, come on. It's no contest, in my opinion.
Lieutenant Colonel Adam Lee, prosecution or defense today?
I'm the only one in the room that's not a lawyer, but even I can tell you, Vinnie, the state had the best day. They have a cornucopia of evidence. The confession is just icing on the cake. They would win this case, I believe, absent a confession, based on what I've seen. So definitely the prosecution all the way. They batted 1,000 today with that confession.
Criminal defense attorney David Schnipper, prosecution or defense today?
Obviously prosecution. It reminds me of an Alabama Crimson Tide football game after the first quarter. It's like 50-0. And I mean, we get back to what the death penalty sentencing, where the aggravating factors need to be shown, and they're being shown. And in some of those, I'll just go off, has he been convicted of a felony in the past? And that's not going to come in now, but that will come in the sentencing phase. Is it a capital felony, i.e. kidnapping? Was it for a monetary gain? Was it cold calculated? Was it premeditated? Was it heinous and vile? All these are different aggravating factors that the prosecution is showing crystal clearly that they're going to show in the sentencing phase. So obviously, yes, it's the prosecution hands down today.
And I'm going to agree with everyone that it was the prosecution had a better day. And I believe it's not just because of the guilt phase, but also how what happened today will impact the penalty phase if we get there, right? If we get there. The fact that he confessed and what he confessed to, why he did it, and how he said it are words this jury cannot forget and will remember if we get to that penalty phase in this trial. All right, that's today. Tomorrow, another big day in this case. Let's check back in with Ted Rowlands at the courthouse with a preview of tomorrow.
Vinnie, coming up tomorrow, the jury will get the case at some point. The big question is, will the defense put up a case? Specifically, will Scott Nelson decide to take the stand? The defense team is talking with Nelson. We assume overnight they will be, and making this decision. That'll be the first thing that we'll find out tomorrow morning at 9 a.m. when court reconvenes, and then the jury will decide Scott Nelson's fate in the guilt phase of this trial. They have been told that they can't come to a verdict during the deliberation period set aside for the judge, that they will be sequestered. So they'll have to go to a hotel in the event that they don't come up with a verdict tomorrow. Tomorrow night they'll be in a hotel and then start deliberating again Friday morning. But the reality is, with the overwhelming evidence in this case, likely we'll be expecting not only the jury to get this case tomorrow, but also come up with a verdict. Vinnie?
All right, thanks so much, Ted. Yeah, and Ted brings up a great point. Tomorrow is the day to be tuned in here because, number one, we're going to find out whether or not this defendant will testify, and that can be an absolutely compelling moment in the court, which may provide even more evidence for this jury in making that ultimate decision. Number two, closing arguments. You will hear the arguments from both sides in this case. Then we'll be in a verdict watch. As Ted said, this jury will be sequestered during deliberations, and usually that means, you know, you have a case that takes a few days. It's a death penalty case. Maybe it takes the jury a few days or a couple of days or maybe a few hours to come to a decision, which means they may have to come back the next day. If that happens here, they're not going home. They're going to a hotel. However, based upon the lack of cross-examination, the confession, and the overwhelming evidence, will we really get there? Will this jury spend a night in a hotel, or will they get this case and deliberate very quickly? That's why you want to be watching Court TV tomorrow for that moment when the jury says, hey, we've reached a verdict, so you can watch it live right here on Court TV. Now, I just want to go around the horn really quickly one more time here on this case to ask the question about whether or not you believe this defendant will take the stand. We've been kind of dancing around it tonight, but I want a yes or no answer and maybe a sentence or two as to why you think so, whether he will or won't testify. Mark O'Mara.
He should not. His ego may make him take this opportunity to be on the stage, as devastating as that will be for his case.
Ashley.
He shouldn't, but he's going to, and I can't wait to see what it's going to be like. It'll be dramatic.
Lieutenant Colonel?
I believe he will. He's narcissistic as far as I can tell. He wants attention. So he wants at least that one last chance to be heard before he gets shipped off to prison.
David Schnipper?
This is somebody who wrote 3 separate letters to 2 judges, which is unheard of. And so he likes to talk, and he's going to get down swinging and yapping, and he's going to want to be heard, like Ashley and Lieutenant said. So I would be shocked if he didn't testify.
Yeah, me too. Don't forget, he turned down plea negotiations in this case. So there's a reason why you do that when you're facing the death penalty and you're kind of like throwing in the towel, seemingly. All right, when we come back, we're going to switch gears, talk about R&B superstar R. Kelly. He was back in court today. You'll see what happened. We'll pick apart his case, facing 4 different accusers in Illinois. R&B superstar R. Kelly back in court today for his sexual abuse case. Prosecutors turned over a DVD which they say shows pornographic images of R. Kelly with a minor. R. Kelly now facing 11 more counts, including 4 of aggravated criminal sexual assault. That's on top of the 10 counts he was originally charged with back in February. Now, last month I spoke with R. Kelly's attorney, Steve Greenberg, about those accusations against his client.
I've seen some of the evidence. I know what some of the witnesses are going to say. I know it's all old evidence. And for instance, let's take one of the cases. There's a case involving someone who said she was braiding his hair. Years ago, she brought those allegations. They were fully investigated. Prosecutors didn't think they could prove the case. Nothing has changed except for public opinion, and public opinion doesn't concern me because I'm operating within a courtroom. You know, allegations are allegations. I could look at you now and say anything I want about you, and it'd just be an allegation, right? You'd say, prove it.
Right, and then I'd say I'm presumed innocent. And R. Kelly went to trial once and was found not guilty in that one, but this time, will it be different? Will it not be? We don't know, but there's something else going on in your world.
Well, hopefully it won't be different because I'd like to see him found not guilty this time also.
All right, so R. Kelly back in court today. He came in front of the judge. We had a camera inside the courtroom. So, of course, this is CourtTV. We're going to show you what happened.
Where are we at now?
Judge, we have tender discovery in all 4 cases this morning. Additionally, in case 19 CR 2761, we are going to tender today a DVD. However, that DVD does contain pornographic images involving a child under the age of 13.
All right. Which case is that on now?
That's 18.
Go ahead.
Under 18, Judge. If I said 13, I meant 18.
Okay. All right.
19 CR 2761.
All right. And I'll enter the protective.
And I've shown counsel the protective order.
All right. All right. I'm going to sign the protective order. I'll say this on the record. I probably don't need to because everybody here is an officer of the court. But if there's any violation of this protective order, I'm going to impose sanctions, severe sanctions, okay? I just want everybody on notice with that. Plus, there could be criminal implications to violation of this protective order. So I'm going to enter the protective order today.
Thank you, Judge. I'm going to tender this to counsel.
And Judge, we're of course going to comply with the order, and we know what the law is, and it's not an issue of any kind. I don't know if the state is ever going to do anything about the dissemination that was done before these charges with their witnesses.
I don't care about what happened before. What I'm saying, as long as this case is in front of me, this order is going to be abided by. And I'm sure, I just want to make that clear.
Right.
Okay. All right, so that's entered.
But it applies equally to the state.
Well, certainly it does. Certainly it does. I understand that, and the state understands it also. Okay. What else do we have today, then?
That's it for the state today.
Okay. What about the defense?
Judge, there were some discs we could not get to open. They've given us new copies of them today.
Okay.
And we'll go through the materials. We discussed the date of August 15th.
Okay. All right. Let me ask you this. Do you anticipate filing any motions with what you have so far?
I anticipate filing a lot of motions.
All right. Let's look towards August 15th as far as starting to get these motions filed. And I'd like the state to start looking at what case you may elect to proceed with first, because I want to move these cases along, okay? So I want you to look at that.
I can tell the court that we met with all of the investigators and the detectives that have worked on this case, just to also implore upon them we want all the reports and discovery finished as quickly as possible. We're going to do our best to complete that if we can, even on the next court date. Defense counsel had previously asked me if he could have a copy of everything from the trial that happened several years ago. We have that on a disc. We are going to get that copy and get that to him.
Okay.
So we are trying very hard to complete discovery, and we should be able to have an answer to Your Honor about an election on the next court date.
Okay, okay. Because quite frankly, I'm looking at setting the elected case for trial next year, early next year.
Okay.
Okay?
I mean, obviously it depends.
And obviously it depends upon the motions and things of that nature, in which case the state makes an election on. But my point is that I'm going to move these cases along.
That's fine.
Okay? All right, what else do we have today? Anything?
Judge, I'm sure there's no surprise, we're going to be filing some motions about statute of limitations. I don't know which case they're going to elect on, or if you would want that filed on everything that we're going to file it. I mean, usually when we know their election, and then we file motions on the election.
Sure. Well, maybe you can talk to the state and see what their position is, and that may allow you to expedite that.
Sure. They know before the 15th.
Sure. Okay. Sounds good.
All right, a couple of things here. There are 4 accusers in the cases against R. Kelly, and those of you who watched the Kellen Winslow trial here knew that in that case there were 5 accusers, but it was just 1 trial. Well, in this case, in Cook County, Illinois, there are 4 accusers. There will be 4 trials if they go forward. It's not going to be all consolidated into one. There'll be separate cases. And just to give you an idea of when these cases are from, you had one accuser, 16 years old, from a case back in 1998, 24-year-old from 2003, 16-year-old from 2009, and someone who was between the ages of 14 and 16 from 1998 to 2001. So the question is, why now? Why are these cases being brought now? Well, one of the reasons may very well be the docuseries Surviving R. Kelly, which millions of people watched, and then everyone was wondering, why isn't this guy charged with anything? Then the prosecutor, Kim Fox, the same prosecutor from the Jussie Smollett case, came out publicly and said, we can't prosecute a case without victims coming forward. So if you've been, if you're a victim, come forward. Well, apparently they did, and now the cases are moving forward against R. Kelly. Want to bring back in my think tank. We got a great panel tonight. Mark O'Mara, David Schnipper, Lieutenant Colonel Adam Lee, and Ashley McMahan, all with me. First question, the fact that it's being tried now, and it all sort of started because of a television show. What is that? How does that impact this entire case, David?
Well, it's interesting you mentioned Surviving R. Kelly, which came out in early January, and it was, I think I read it was Lifetime's most watched.
Absolutely.
I think over 2 million viewers in the last 2 or 3 years, and obviously in the court of public opinion with everybody watching that, then the prosecutorial agency in Cook County felt pressure to move forward now. And like you said, the DA there then felt pressure again. Now, my only thing with this is you're going to have 4 different trials. How are you going to find a jury pool that's not tainted? I would assume there's going to have to be some filing motions of change of venue here. And how it's going to be so tough.
I don't know where you can change it to, because this is one of those cases that everyone knows about everyone. Now, Mark O'Mara tried one of those cases that everyone knew about. You can get a fair jury, right, Mark?
You really can. I mean, I understand the concern, but in this day and age of social media, instant media, 24-hour cable TV access, we know a lot about, it's not all accurate, but we find out a lot about a lot of cases. However, the Zimmerman case as the example, that was a very highly publicized case, a lot of focus, but it took us a few days, just over a week and a half, and we got a jury. And you can get one. They will get one in this case. They get one for all 4. It's going to take some doing, just like they found one here, just like they found one in the Cosby case. It's not difficult to find a jury, it just takes more time and effort. But it is amazing that in today's day and age, literally a TV program caused the prosecution, but that is the universe that we now live in criminal defense.
And Ashley, the other thing that struck me was the discussion about this protective order, and that had to do with the nature of these DVDs, right? It has people, purportedly a minor, underage, engaged with R. Kelly in these acts, these pornographic acts. Of course, the prosecution is saying criminal acts, but you can't just give those out to anyone. You can't distribute. That's a crime if you distribute child pornography. Not allowed to do it. When I was a prosecutor, they didn't even hand it to the defense. The defense had to come to the prosecutor's office to view it. They didn't get a copy of it.
I agree, and this is very common with these types of cases. I mean, you want to protect the identities of anybody that may be a minor on these tapes and on these CDs, these DVDs, and you also don't want to be guilty of distribution of child pornography potentially when, the DVDs start getting passed
And the
around.
prosecutor can do that as well, or witnesses in this case if they gave it to other people and made copies.
Yep, you're absolutely right. And the judges do not mess around with these type of protective orders. You saw how serious he was, and he was like, look, if anybody, the state or the defense, violates this protective order, sanctions are coming down immediately, and potentially criminal charges on top of that. So yeah, this judge is taking this very seriously, and I think he should in this case.
Now, R. Kelly is presumed innocent like every criminal defendant. Went to trial once and was found not guilty years ago. That case took, I think, about 5 or 6 years to actually get to trial. This judge is pushing the schedule a little bit quicker than that. But Lieutenant Colonel Adam Lee, I want to ask you, R. Kelly, if he's ever convicted on any of these cases and is then incarcerated, what is life like for R. Kelly as an inmate?
Unfortunately, it depends on how much money he has, because of the level of malfeasance that goes on in some institutions and with the inmates. If he can pay for protection, you know, there's bound to be some extortion going on amongst the inmates trying to protect R. Kelly because they like him. He's, you know, maybe they were his fan of his, so he'll get those inmates that'll try to protect him. But generally speaking, someone who commits or is convicted of a crime dealing with minor, especially women, females, is going to have a hard time in prison, and the staff in the prison is going to have a hard time trying to protect him from violent acts because he will be a consistent target.
All right, now, again, he's presumed innocent, hasn't been convicted of anything, just looking ahead at what could happen here. Now, here's a question I have for my entire panel. The fact that R. Kelly is R. Kelly, R&B superstar, sold millions and millions and millions of records, DVDs, downloads, however you get your music, made a lot of money. People know who he is. He is an A-list celebrity. I'll start with you, Mark O'Mara. Is that an advantage or disadvantage for R. Kelly?
It's just not that simple, because it really is an advantage. It's going to be difficult to convict R. Kelly of anything like it is with almost any celebrity. That being said, this is a child abuse, a sexual abuse case. Nobody likes those, and they defer to the prosecution on those constantly. So I think in balance, the celebrity is not going to win out over the crime.
All right, we only have time for a quick answer. Advantage or disadvantage?
Like Mark said, it all depends. I mean, juries are quirky. You never know. I mean,
so you're not answering my question.
I think it can be an advantage because, and the reason is unfortunately or fortunately, entertainers, sports figures are role models, and so we look up to them. And so you find, so you would assume that some people in the jury would look up to something like that. Oh, it's neat that R. Kelly, they'll be more into it, and they could find.
I've seen many celebrities found not guilty in my years at CourtTV. All right, coming up, an argument over a handicapped parking spot leads to the death of a man. The shooter says it was all in self-defense.
I need justice. This is not right at all. Jacobs was the first person Michael Dryka confronted after she parked in a handicapped parking spot. Surveillance video from the store shows McLaughlin leave to defend Jacobs. Moments later, he shoves Dryka hard to the ground. Dryka then pulls out a gun and shoots McLaughlin square in the chest.
Dryka told detectives he was in fear after, quote, being tackled to the ground, and that after McLaughlin made a, quote, twitch towards him, he fired in self-defense.
Michael Dryka initially wasn't charged by the Pinellas County Sheriff, citing Florida's Stand Your Ground law. Nearly a month later, Dryka was charged with felony manslaughter.
Dryka's history in uttering racial slurs will not be allowed in the courtroom. But one past incident will be allowed. Ricky Kelly explained to the judge today that just months before the fatal Marquise McLaughlin shooting, Dryka confronted him and threatened to shoot him after he parked in a handicapped parking space.
That he is a dangerous man. He is a vigilante. He's a wannabe cop.
It's still ludicrous how you can claim that you're in fear of your life, but yet you approach and start the confrontation.
From church, a march in the streets, to a rally outside the store where Marquise McLaughlin was shot and killed.
He was loved by a lot of people, but just to see how many people that actually came out, you know, just to show their support, show him love, overwhelming.
He could have walked away with a bruised ego and a bruise behind. Instead, he took a person's life.
Florida versus Michael Dryka is scheduled for trial this summer, August 19th. Of course, CourtTV is tracking that case for you. A couple of notes about this case, and people have drawn a lot of comparisons between this case and the case involving George Zimmerman. And there are some similarities, but there are some huge differences. First of all, there is the videotape. That is one big difference. Second, there is a witness, Brittany Jacobs, who is the girlfriend and the mother of the children of Marquise McLaughlin, the man who was shot and killed. She was there in the car. She saw and heard what happened. What she didn't know at the time was she was carrying Marquise's child, their third child, together. So this is a heartbreaking case on many levels, but he is claiming self-defense. As a matter of fact, he has given interviews. Take a listen.
Yeah, I was very scared. It felt like I was tackled or someone hit me from behind with something. I followed the law the way I felt the law was supposed to be followed. I cleared every hurdle that law had to put in front of me. My whole life has always been looking for a handicap parking spot. Right. And it's always touched a nerve with me. So the idea is that they're abused and used.
All right, I want to bring in my think tank tonight, and it includes the man who represented George Zimmerman, Mark O'Mara. First thing I want to get is when we look at that videotape, and we've shown it a few times already, you'll see it again. You may be familiar with it. I know, Mark, you've seen it. When you see that videotape, what do you see, Mark?
Well, first of all, I like having videotapes. I love body cameras. I love any type of video evidence because it's a lot better and a lot more accurate than people's memories or their interpretations of what happened. But what I saw on that was, unfortunately, the eventual victim in this case was an aggressor. The push down, though felt right when you're defending your family, isn't appropriate. It's still a crime. Drejko responded, I think, over-responded to that threat and used deadly force when he did not need to at that point. That's going to be a tough call for the jury to make.
Absolutely. Lieutenant Colonel, what do you see when you look at that video?
I see a man defending his wife. I don't think there's many men that would not have acted in at least a similar way, either verbally.
And you're talking about the man who got shot, Marquise McLaughlin.
Right. I believe, if it had been me and I walked out of the store and I see a man, a stranger, berating my wife over a parking space, I would have taken some sort of action. I don't know if it would have been physical, but the video doesn't have audio, so we don't know what was said prior to him pushing the man down. So that's the one part that's missing that would be beneficial. If we had a little audio to go with it, we might know a little more than we do.
Ashley, what do you see when you see that video?
I have to agree with the lieutenant on this one. I'm actually pretty shocked that with the video in this case, that we're not afforded in every single case like this, that he wasn't charged immediately, or at least held and interrogated for longer, and I'm really surprised that the police took as long to charge him with this case.
David, what do you see?
I agree with Mark. I think that, and Lieutenant, that, anybody's going to defend their family, but there's a limit for how far you can go. So as Mark alluded to, he was overkill. And we know that Florida has the stand your ground rule, but that you have to be in imminent fear almost for your life, and I feel that he did go too far, and he's rightly charged. But again, from what I read was that they were going to have an immunity motion, a self-defense motion, but they've passed on that because there was a prior incident that occurred not even like a month ago where the defendant was in the same situation, and they're going to pass that, which is smart because the defense doesn't want to show all their cards, and they're going to take it to a jury trial.
Now, when I see that videotape, I think that the crucial part is, yes, there's the push and the shove, and he goes to the ground, all right? Watch here. You got the push. He's back on the ground, but now watch Marquise McLaughlin. As the gun comes out, he's backing up. He's moving away. And I believe the jury will focus on those two steps as being the key to this entire case. What do you think about that, Ashley? The fact that, as we watch this video, at the moment he pulls the gun out, right? He pulls the gun out, we're looking at it, and then here comes the gun, and now he's backing even before the gun, but now he's even going back further. I think the jury's going to focus on that.
Oh, I couldn't agree more with you, Vinny. I mean, I think what they're going to see here is him saying, look, I had just been tackled. I was in reasonable fear for my safety. I saw him twitch, I believe is the exact
That's what he says, yeah, twitch.
that he used. And this video is clear as day. You know, Marquise is backing up. He takes 2 full steps back before he is shot. So I don't know how the defense is going to be able to spin this and say that he was reasonably in fear for his life while his eventual victim, is backing away from him.
And Lieutenant Colonel, obviously, you're trained in how to use a firearm, when to use a firearm. Your thoughts about, you've got the shooting victim backing up at the moment.
Deadly force is definitely not justified at that point. Had this man been an officer